I'm Joel Chandler. Welcome to another episode of Unsealed. In this limited podcast series, I take you behind the scenes for an unfiltered look at various open government projects that I've worked on in the past, projects that I'm currently working on, or projects that are still in the planning stage. We also discuss various issues that intersect with open government in Florida. Before we begin, I'm not an attorney. I am not qualified, nor am I authorized to give members of the public legal advice, so I don't. What I'm sharing in this episode is based on my own experiences working on open government issues here in Florida since 2008. I'm sitting in a deposition. Across from me is a witness for the defense. The witness is the person who handled my public records request, and their attorney is sitting next to them. Now, we've been going for about an hour. The court reporter is diligently taking down every word. I'm looking at the agency's response to my lawsuit, and right there in black and white, it lists improper purpose as an affirmative defense. And so I asked the witness, are you aware of any evidence that supports the allegation that I requested these records for an improper purpose? The witness looks at their attorney, then back at me. I'm not aware of any evidence like that. I follow up. Did anyone at your agency investigate whether there was an improper purpose before that defense was raised? No, not that I'm aware of. Did anyone contact the organizations that asked me to get these public records and ask about their purpose? No. Did you or someone else at your agency authorize or approve that affirmative defense? Yes. And that affirmative defense was authorized and made by the agency attorney, even though there is no evidence to support it? Yes. This happens in almost every case, almost every single one. In today's episode, we're going to talk about that phrase, improper purpose. It shows up routinely in Florida public records litigation. It sounds ominous, serious, it sounds accusatory, and it has become a catch-all defense in public records litigation. But the real meaning of improper purpose, the legal meaning, is almost nothing like the way it's used. It's obvious that the attorneys using it haven't spent much time trying to understand it. They haven't read the limited case law or the legislative history. They make that argument knowing they have zero admissible evidence to support it. Their clients expect them to do something, so they grasp onto the first thing they can find. And as they say, the die is cast. So today we're going to do a deep dive into improper purpose. We're going to look at what the statute actually says. We're going to discuss the only two court orders that define the boundaries of improper purpose. And we're going to dig into the legislative history behind the 2017 amendment that added improper purpose to the legal lexicon. We'll examine what lawmakers believed and how those beliefs shaped a statute that now requires courts to evaluate motive in every single public records case. We're also going to compare that history to how improper purpose actually plays out in real life, in pleadings and in discovery and in the day-to-day work of people who make public records requests. The first thing to understand is this. Improper purpose is not about whether a requester is annoying. It's not about being persistent or unlikable or outspoken or inconvenient. It is not about tone or personality. And it's not about whether an agency believes the requester is a troublemaker. Under the statute, as written, and under the only two court orders that have ever interpreted it, improper purpose has a precise meaning: a frivolous lawsuit, a lawsuit that no reasonable person would make or file, not poorly written, not weak. Frivolous. And that distinction matters because Section 1912 of the Florida Statutes doesn't just allow courts to examine motive, it requires them to do so. Even when an agency does not assert improper purpose as a defense, the statute says, the court shall determine whether the complainant requested to inspect or copy a public record or participated in the civil action for an improper purpose. Not may, not if raised, shall, which means every judge in Florida hearing a public records case is put in the position of weighing motive, something courts never did prior to 2017. And that's one of the strangest features of the post-2017 statute. It splits the world in two. On one side, you have agencies. Agencies who, no matter how suspicious, irritated, or offended they may be, are legally prohibited from considering a requester's motive. And on the other side, you have courts. Courts who, under the amended Section 1-1912, must hold an evidentiary hearing and evaluate motive in every public records lawsuit, even where no one raises it as a defense. Agencies cannot weigh motive because case law addressing the Florida Public Records Act has said for decades clearly, repeatedly, and without qualification that motive is irrelevant to the right of access. But courts, after 2017, must weigh motive because the legislature told them to. The best articulation of why agencies are prohibited from considering motive, or even the personality of a requester, comes from a case cited in the Florida Attorney General's Government in the Sunshine Manual. Church of Scientology, Flag Service Organization, Incorporated versus Wood. It's a 1997 circuit court case from Pinellas County. For decades, there has been a tense dynamic between the city of Clearwater and the Church of Scientology. I think I'm putting that mildly. The Church of Scientology's international headquarters is located in downtown Clearwater, and over many years the church has become a major landowner in the city's center. In the wake of the death of a young woman named Lisa McPherson in 1995, there was an autopsy conducted by the medical examiner in Pinellas County. McPherson was a member of the Church of Scientology. There was a lot of media controversy surrounding her death. It was a national news story at the time. The church submitted public records requests to the medical examiner. They ultimately sued to gain access when they claimed they were not allowed access to the records as required by law. The trial court judge, a man named Bob Barker, not the game show host, but a circuit court judge in the 6th Judicial Circuit, agreed. He ruled in favor of the church. His written order is worth discussing because it is uncommonly direct. Judge Barker laid out the principle in plain language no agency could misunderstand. The law provides any member of the public access to public records, whether he or she be the most outstanding civic citizen or the most heinous criminal. A person's motivation in seeking public records is irrelevant. The law guarantees anyone the right of access without requiring justification or demonstrating good cause. That language is emphatic. It doesn't hedge. It doesn't carve out exceptions for tone, volume, persistence, annoyance, or whether the custodian thinks the requester is a jerk. The law makes no distinction between good and evil. Those are the judge's words. And yet, inside agencies, there is a different reality. The reactions to public records requests are often some version of, he's doing this to set us up. She's not really after the records. They're just trying to sue us. We shouldn't have to respond if it's harassment. But Chapter 119 does not allow those considerations, not even a little. Agencies cannot refuse access because they dislike someone's motives, or suspect their intentions, or imagine a lawsuit around the corner. Motive is legally off limits for them, by design, not by accident. Why? Because if motives mattered at the intake window, access would become a personality contest, and government would regain the power our legislature and the courts have repeatedly stripped from it. The Public Records Act affords the public's right to public documents sacrosanct status, not subject to a custodian's intuition about who is good, bad, so worthy, or suspicious. Agencies don't get to play moral gatekeeper. They never have, and they still don't. That responsibility, the only place where motive enters the legal analysis, belongs exclusively to the judiciary. But before we talk about whether that framework makes sense or whether it works or whether it was ever necessary, we need to look at what the courts have actually said. Because for all the noise around improper purpose, there are only two meaningful cases that tell us anything, Vitale and Lee. And they both say something important, not just about public records, but about how courts view power, access and the line between persistence and abuse. It's important to point out that these two cases, Vitale and Lee, address the litigation part of Section 119.12, but they do not address the request part of that section. So at least for the time being, we can only speculate about what the standard might be for a request. Remember, in 2017, Section 119.12 was amended to read, in relevant part, the court shall determine whether the complainant requested to inspect or copy a public record or participated in the civil action for an improper purpose. The complainant would be the person who made the public records request. The civil action would be a lawsuit. The orders in Vitale and Lee don't really address the actual request. They don't give us clarity about what a request for an improper purpose would look like. What the judges in Vitale and Lee do give us is clarity about what participating in a civil action for an improper purpose might look like. Let's start with Vitale versus Palmetto Charter School Incorporated. That's spelled Vitale. It's a case from Manatee County that began in 2021. It was appealed to the 2nd District Court of Appeal in 2024. A final order was entered by the trial court judge in January 2025. According to the circuit court's written order, and I'm emphasizing according to the order because I'm not making factual findings here, the requester was an attorney described by the judge as a legal bully. Someone who had, in the court's view, behaved aggressively, unprofessionally, and provocatively toward the agency, a public charter school. The court had no difficulty criticizing that conduct. Judge Nicholas made observations that were unvarnished. But despite all that criticism, despite calling the requester a legal bully, despite finding the plaintiff abrasive, difficult, and combative, the court refused to find that Vitale's lawsuit was commenced or maintained for an improper purpose. Why? Because for all the bluster, the lawsuit itself wasn't frivolous. It wasn't something no reasonable person would file, and that is the legal boundary as Judge Nicholas saw it. Judge Nicholas was essentially saying, you may be unpleasant, you may be unreasonable, but that does not make your lawsuit improper under the statute. In other words, hostility does not equal improper purpose. When I first read the order in Vitale, I immediately thought about the Church of Scientology versus Wood. These two cases were different, certainly, but to me they seemed to rhyme. I've never met the plaintiff, Ben Vitale, but I've been in front of Judge Nicholas a few times, and I know the attorneys on each side. Judge Nicholas, Vitale's attorney, Andrea Mogensen, and the attorneys for Palmetto Charter School, Braxton Padgett, and George T. Levesque, are all people I've dealt with, and I know they understand the Public Records Act. Andrea Mogensen is arguably one of the most experienced and successful open government litigators in the state. And you'd be hard-pressed to find another attorney with more open government appellate wins. So the outcome of this case was not the result of inexperience or ineptitude. I mention that because on some level, the outcome is not very satisfying. I don't mean to suggest the court got it wrong. I don't think it did. In fact, given the scarcity of case law on this issue, I think Judge Nicholas did an extraordinarily good job navigating the facts and the law. What I mean is the law itself is so vague and, as we will discuss a little later, so unnecessary that the whole exercise, which lasted from 2021 until 2025, was the result of fiction, not fiction in the Vitale case itself, but the fiction the 2017 amendment was based on. Now let's look at Lee, because this is the only public records improper purpose case where sanctions were actually imposed and then upheld on appeal. And man, those sanctions were serious. Let me say this clearly and respectfully. I don't know Curtis Lee. I've been told Curtis Lee has suggested we have worked together, but as far as I can recall, I've never met him. I take no position on him personally. And I don't trust the source that claims Curtis Lee says we've worked together. Why would he? It's important to note that Curtis Lee was the Lee in Board of Trustees versus Lee, one of the most significant open government cases in the last 40 years. He and his attorneys deserve full credit for that case. Among many other things, that case established a strict liability standard for public records litigation. In layman's terms, the requester doesn't have to show anything more then the agency violated the Public Records Act. The case eliminated any good faith or inadvertence defense. Either the agency complied with the law or it didn't. But in the later public records case, the one that created the improper purpose precedent, the court's written order describes conduct that the judge concluded no reasonable person would engage in. According to the order, the state attorney's office bent over backwards to comply with Lee's confusing, shifting requests, even creating records that didn't originally exist just to help make sense of what was being asked for. And still, according to the order, Curtis Lee sued anyway. Judge Catherine Weston found the lawsuit was commenced and maintained for an improper purpose. And when she did, her 15-page order leaned heavily on the logic of Section 57105, Florida's frivolous litigation statute. She didn't use 57105 itself to sanction the requester. She used it to define the standard. The judge essentially reasoned that if Curtis Lee's conduct would be sanctionable as frivolous under 57105, then it meets the standard for improper purpose under Section 11912. The First District Court of Appeal affirmed the circuit court's finding in a per curiam affirmation, or euphemistically a PCA. A per curiam affirmation is when an appellate court affirms a lower court's decision without issuing a written opinion explaining their reasoning. As a side note, I hate PCAs because they don't explain the appellate court's decision or its thought process. If it were up to me, every appellate decision would require a written opinion. But that's the way it is. And as one appellate court put it, when an attorney was dismissive about the authority of a PCA, the A stands for affirm. So that means, like it or not, Lee is the only binding appellate interpretation we have. So what do Vitale and Lee tell us? They tell us that improper purpose exists only at the extreme margins, when the facts are so far outside the norm that the lawsuit itself cannot be justified by any reasonable person. And that is a very high bar. Very few cases will ever meet it. And now that you understand the legal framework, the real legal framework, we can talk about how we got here. Why the legislature rewrote the statute, and why the culture inside many agencies consistently misuses improper purpose as a red herring rather than a valid defense. So if the courts have been clear, if Vitale and Lee bracket the issue of improper purpose, at least regarding litigation, how did we end up with a statute that now requires every judge in Florida presiding over a public records case to evaluate motive, even when no one raises the issue? To understand that, we have to go back to 2017, when the legislature amended Section 11912 based on a story they believed, a story they trusted, and a story that, put bluntly, didn't reflect reality. Back then, lawmakers were told there was an epidemic of gotcha public records litigation, that people were setting traps and ambushing agencies with obscure requests, then filing lawsuits for sport or profit. They were told activists were intentionally targeting junior staff who didn't know the law. They were told public employees were being harassed and baited. And they were told that millions of taxpayer dollars were being siphoned away because of minor technical mistakes. It was alarming. And for some lawmakers, it was persuasive. Today, we would call that an algorithm problem. People weren't getting complete information. They were getting customized information, tailored to their inboxes and their feeds by lobbyists and professional associations in their orbit. The same legislature that couldn't agree on the budget could agree on this, because they were all being shown the same largely fabricated story, a story built on exceptions, a story built on colorful anecdotes, a story built on a handful of unusual events repeated so often they became folklore. But anecdotes and folklore aren't evidence, but when it's repeated often enough to legislators, sometimes it becomes the law. Nothing illustrates that more clearly than the case the legislature relied on most heavily, the Lutheran Social Services case, or more commonly known as the LSS case. My name appears repeatedly in the final order, so let me be transparent about my actual role. I wasn't a party. I wasn't a witness. I didn't testify. I had no financial interest whatsoever. I rode to a hearing in Jacksonville because the plaintiff's attorney, Abraham Shockfey, wanted someone to talk public records with on the long drive. When we arrived, I sat quietly at the conference table in the judge's hearing room. Opposing counsel objected to me sitting there. Abraham told the judge I was his legal assistant, so I didn't have to move. That was the beginning and end of my involvement. After the hearing, I didn't even get a ride home. I took a Greyhound bus back to Lakeland because Abraham was headed elsewhere. Yet somehow, the final written order devoted paragraphs to me, a non-party with no ability to appeal any finding the court made. A court criticized someone who had no opportunity to present evidence, no standing to respond or offer testimony, and no recourse to challenge the statements later. And that order, despite those flaws, became the foundation for a legislative narrative that still echoes today. Not because lawmakers were malicious, not because they were hostile to transparency, but because they were given a story that seemed to explain everything, a story that made it look like the problem was rogue requesters, not agency noncompliance. The overwhelming supermajority of public records lawsuits weren't caused by trickery. They were caused by agencies failing to follow the law. The narrative, one that I still contend was largely based on fiction, was that unscrupulous requesters would deliberately direct their public records request to agency personnel who would almost certainly not know how to respond. One anecdote claimed that a request was made to a groundskeeper riding a lawnmower. If something like that ever happened, I never witnessed it. And I've never met anyone who claims to have done that or witnessed it. But based on that anecdote and others like it, the legislature added to 11912 a requirement that requesters who later sue and seek their costs and reasonable attorney fees must, 1, direct their request to the agency's custodian of public records, and 2, must give the agency a 5-business-day written notice of their request before filing suit. In my opinion, legislators believed that if requesters were required to make their public records requests to the actual records custodian, then there would be no more public records litigation because the agency records custodians would always respond properly. That would have been a perfectly rational belief if the problem was requesters and not the agencies. Most agency records custodians, however, aren't trained and do not know how they should respond to a public records request. There are exceptions, of course. Municipal clerks are the obvious exceptions. As a group, municipal clerks in Florida could run circles around 99% of the Florida bar when it comes to public records law, but they are the exception. The other problem with the notice requirement added by the legislature in 2017 was the requirement that agencies prominently post the contact information for the custodian of public records in their websites and in their primary administrative offices. If the agencies do not do both, then the notice requirement is waived. I make lots of public records requests, and before every one of them, I visit the agency website to see if they post the contact info for the records custodian. Well, over 90% of them don't. So the notice requirement, which I think legislators supported in good faith, was intended to solve a problem that didn't exist. The issue wasn't requesters being tricky, it was records custodians being inaccessible or illiterate with respect to the Public Records Act. And even with the amendment of 11912, that hasn't changed. And the frivolous lawsuit problem, it was never widespread and is still extremely rare, as evidenced by the fact that in the years since 11912 was amended, only 2 courts have addressed it. And when it did happen, judges already knew what to do. They leaned heavily on a statute that has been around in one form or another for decades, 57105. Long before improper purpose existed, Florida courts had a powerful mechanism for sanctioning frivolous litigation. It has decades of case law, clear standards, appellate guidance, and teeth. That's why the judge in Lee leaned on 57105 logic, because the statutes overlap. If improper purpose had never been added to the Public Records Act, Lee would almost certainly have come out the same way. So, what changed? Judges must now hold an evidentiary hearing to determine the motive of the requester, even if no one raises the issue, whether it helps or hurts the requester, whether it's relevant or not, whether the agency complied or ignored their responsibilities. Every case is now required to include a moment where motive takes center stage. Ironically, most judges don't do that. I'm no stranger to public records litigation, so I speak from experience, and most courts never address the issue. In the rare instances when they do, it has generally been like one exchange I had with a judge. Mr. Chandler, tell me why I should treat this as a legitimate request. I answered honestly, and that's the end of it. I recall one hearing before another judge that told me to stop talking when I tried to address the purpose of the request in response to defense counsel's questioning my motives. As the judge put it, I don't care, and it doesn't matter. Mr. Chandler, you have an absolute right to ask for public records. I have probably been in front of those two judges more than any other judges in my career. I happen to think they are the two finest open government judges in the state. And that's not because they always rule in my favor, because they don't. But even these two very capable jurists don't seem to agree on how 11912 is supposed to operate. That's not a criticism of those judges. It's a critique of the statute itself, at least on the issue of how improper purpose is applied to the request rather than the lawsuit. It's still a mixed bag. I know we've been deep in the weeds with legislative history and statutory language, but stay with me because this matters. The story the legislature believed in 2017 is still shaping how agencies behave today. And that brings us to what happens in practice. Agencies routinely raise the improper purpose defense, but agencies also routinely ignore the evidence. Sometimes they don't read the requests, they don't open the attachments, they don't watch the explanatory videos, they don't read the transcripts, they don't log into the Zoom meetings about upcoming requests, they don't participate in mediation, they don't contact the people who asked for help getting the records in the first place. Instead, they follow a script from 2017, a script built on myths. The script says, if someone is asking for records, they must have an angle. If they're asking aggressively, they must want litigation. If we don't understand the request, they must be setting a trap. None of that is true, but the culture inside many agencies still acts like it is. And that brings us to something that almost no one outside this process ever sees: the evidentiary trail that thoughtful requesters create. Here's what my process looks like. The request is written, clear, delivered in a way that creates a record, either by FedEx, certified mail, fax, or email, but always in writing. The request includes an explicit offer to clarify. If the agency misunderstands anything, I'll fix it. The request includes an invitation to participate in free, state-run mediation. Mediation conducted by Pat Gleason, the Assistant Florida Attorney General who has been writing the Sunshine Manual for more than 2 decades. If the agency fails to post custodian information, which most fail to do, the statutory notice isn't required, but I still send written notice anyway. That means my initial request is made in writing with proof of delivery. Then, even when the requirement is waived because the agency does not post the record's custodian's contact info, I still send a written notice of my original request. Sometimes I send multiple written notices. My requests generally include a thumb drive that contains, or a direct link to, a digital copy of the most current edition of the Florida Attorney General's Government in the Sunshine Manual, digital files of my podcast, including Artificially Informed, my deep dive into the Sunshine Manual, Unsealed, which this podcast episode is a part of, including episodes that give practical insight into how agencies can better respond to public records requests, transcripts of every podcast episode, and an invitation to use the artificially informed custom AI solution based on the Sunshine Manual, which is also part of my digital signature in every email I send. I also include video and audio recordings of Zoom meetings with agencies discussing various projects and the associated public records requests that I make. In advance of those Zoom meetings, I usually send an invitation to attorneys who represent those types of agencies, charter schools, public housing authorities and the like, and I send invitations to industry associations too, the agency receives all of it in the normal course of business, which means these items become public records when they are received by an agency, and as certified copies, those public records are self-authenticating. This isn't strategy. This is what transparency looks like. None of this resembles the conduct described in Lee. None of it resembles the behavior the legislature feared. None of it even remotely fits the standard for frivolous litigation under 57-105. The purpose isn't just legitimate, it's spelled out, over-explained, documented in writing, audio, and video, sent directly to the agency and published before a request is ever made. Which leads to the question I ask in almost every deposition: what evidence do you have to support the improper purpose defense? And the answer is always the same. Always. Some version of none. Or I'm not aware of any. Or that's something the attorney put in. I don't know anything about it. And this is where the conversation inevitably turns toward PMJA, the Poor and Minority Justice Association, and the person who asked me to work on one of several social justice projects that depend on access to public records, Pastor Clayton Coward. If an agency genuinely believed that improper purpose was a real issue, if they truly thought there was an ulterior motive, the one person they would need to talk to is the man who asked me to get the records in the first place. Of course, Pastor Coward and PMJA aren't the only folks to ask for my help in accessing public records. I receive requests for help routinely from corporations, both for profit and not for profit, associations, political campaigns, churches, individuals, attorneys, and even public officials. I've lost count of the number of times I've been contacted by public officials asking for my help in obtaining public records. Either they are concerned about potential blowback or retaliation and want to obtain the records anonymously, or they need records from another public agency that simply won't cooperate. That is especially common between law enforcement agencies when it comes to gypsy cops. Sometimes a public official knows about something within the agency that shouldn't be happening, and they will direct me to a specific public record that they want me to request in hopes I will forward what I find to the proper authorities or the media. So if improper purpose is almost never real, the courts have defined it narrowly. And if the legislature was reacting to myths, why does the defense keep showing up? Why do agencies use it so often? The answer has very little to do with statutes and everything to do with culture. Some agencies in Florida value transparency. They understand it. They embrace it. They train for it. They prepare for it. Those agencies almost never get sued, certainly not by me. But most agencies see public oversight as a nuisance, not because they're corrupt, not because they're malicious, but because they have absorbed a culture that treats transparency as something extra, something optional, something burdensome. In those agencies, public records requests are seen not as a constitutional right, but as an interruption. That attitude starts at the top and spreads, moves into policy, filters into staff behavior, and eventually becomes a reflex. And when that reflex exists, when a culture is already primed to assume bad motives, everything looks suspicious. Requests look suspicious. Clarification offers look suspicious. Follow-ups look suspicious. Even compliance looks suspicious, as if producing the record somehow validates the requester's agenda. That's how you end up with a statute intended for extraordinary abuse being used as an everyday narrative tool. I've said this in previous podcasts, but I think it bears repeating. If an agency's response to a public records request isn't some version of what can we do to make these records available to the public, eventually that agency will almost certainly end up being the defendant in a public records lawsuit. What agencies too often do is think in terms of what can we do to avoid producing the requested records. That is why public records litigation happens, and that's why it should happen. Most public records failures are not caused by confusion or training gaps or workload or resources. They're caused by a failure of leadership. When agency leadership believes transparency makes them better, that agency almost never ends up in court. They respond promptly, They respond accurately. They treat oversight as part of public service. And importantly, they respond to members of the public with courtesy and respect. They do not assume an adversarial demeanor. But when leadership resents oversight, everyone else does too. And when leadership encourages, directly or indirectly, a defensive posture, public records compliance becomes adversarial. It's a cultural failure with real-world consequences. It creates litigation. It makes agency staff adversarial with the public it is supposed to be serving. It normalizes delay. It erodes public trust. And it wastes enormous amounts of public money, often on private law firms, churning billable hours on affirmative defenses they have no evidence to support. This cultural resistance isn't new. In fact, it's the same impulse the founders fought against, which brings us to the foundation beneath all of this. Open government is not modern. It is not new, and it is not optional. It is rooted in the founding document of this country. If you read the Declaration of Independence, you will find something that almost no one talks about. Two of the reasons the colonists declared independence were being denied access to public records and being shut out of government meetings. That's not interpretation. That's not extrapolation. That is literally in the text. Long before the state of Florida existed, long before anyone had heard the words Public Records Act or Sunshine Law, long before there were audits or transparency laws or sunshine manuals, the fight was already about access, about decisions made in the open instead of behind closed doors, about the right of ordinary citizens to know what their government was doing, about the principle that information belongs to the governed, not the governors. Open government is not a modern reform. It is one of the reasons we exist as a nation. And here in Florida, we didn't just adopt that idea, we expanded it. Article 1, Section 24 of the Florida Constitution guarantees access to public records and public meetings. It was adopted by the largest supermajority of any constitutional amendment in our state's history. Think about that. Not tax policy, not criminal justice, not education, not healthcare, transparency. Floridians across geography, across ideology, across race, across generation agreed overwhelmingly that access to information is essential to self-government. They understood what was at stake because the consequence of a lack of transparency isn't inconvenience. It's not inefficiency. It's not mild embarrassment. The consequence of a lack of transparency is abuse. When you look at major scandals in Florida's history, the ones that left scars, the ones that changed laws, the ones that shook communities, the pattern is so consistent it almost becomes a template. The Dozier School, the Sunland Hospital System, the state juvenile boot camps, corruption and sexual abuse by housing authorities, police misconduct, those kinds of stories become public because someone demanded records. And for the establishment, the people demanding the truth were nuisances, troublemakers. In my experience, the improper purpose defense plays out something like this. A defense attorney raises improper purpose without any factual basis and then privately tells the agency, "Don't worry, we'll find something in discovery." But they never do because the evidence doesn't exist. I know this because I know why I'm making my public records requests. They are part of a project for PMJA, or it's an ad hoc request that relates to a specific event, a police shooting, for example, and Pastor Cowart has asked me to obtain records so he can verify the claims being made by the parties involved, or a different third party, someone other than PMJA, has asked for help in obtaining public record. And after months of billable hours, depositions, emails, conferences, and motions, sometimes the case goes all the way to trial. Not because the defense had merit, but because the defense had momentum. In George Orwell's essay, Shooting an Elephant, he describes a colonial official working for the British Empire in Burma in the early 20th century being forced to shoot an elephant he didn't want to shoot. Not because it was the right thing to do, he knew it wasn't, but because a crowd had gathered, they expected it, and once that expectation was set, once the momentum started backing down, became impossible. That's what happens here. Once improper purpose is raised, once the The depositions are scheduled once the discovery requests go out, once the invoices start piling up, but backing down becomes unthinkable for too many defense attorneys and their clients. Because backing down means admitting they should have conceded liability from the start, admitted the violation, and moved straight to a fee hearing. That would mean admitting the entire defense strategy was a waste of time, of money, of credibility. So the case continues, not because anyone still believes in the defense, but because no one is willing to admit they were wrong, and of course they aren't paying for it. The taxpayers are. So after all of this, the case law, the culture, the legislative history, the workflow, the narratives, the misunderstandings, what are we left with? A simple truth. Improper purpose isn't about bad actors. It's about bad assumptions. It's about agencies assuming that anyone who asks questions must have an ulterior motive. It's about lawyers assuming that raising every possible defense is better than doing what's in the interest of the public being served by the agency rather than the interest of the agency itself. In other words, it's another example of the entity trap. I understand that transparency feels threatening to people who don't welcome it. But the truth is that agencies that embrace transparency fully, openly, and with intention almost never get sued. Because litigation, in the end, is a symptom. Not of bad requesters, not of ulterior motives, but of leadership that views public oversight as an intrusion rather than a constitutional guarantee. If this episode leaves you with anything, it should be this. Transparency is not an obstacle to government. It is the instrument that keeps government honest. It is the mechanism that allows the public to participate. It is the foundation of trust. The Declaration of Independence listed the inaccessibility to public records and government meetings as reasons for revolution. Floridians wrote transparency into the Constitution by the largest margin in state history. And every meaningful reform in the past century, from civil rights to policing to education to public spending, has come from people demanding government transparency. The problem isn't purpose, access, or oversight. The problem is the culture that treats these as threats. When transparency is honored, when it is protected, defended, and taken seriously, the entire system works better. For agencies, for officials, for communities, for everyone. Transparency isn't a burden. It's what makes us better. I'm Joel Chandler. Thank you for listening to another episode of Unsealed. Remember, the truth dies in the dark.